Intestacy is where a person dies without leaving a will. The person who has passed away is referred to as the intestate. The law sets out that if you die without a will, an application will need to be made to the Supreme Court by the surviving spouse or children looking for an order for that estate to be allocated in agreement with the intestacy rules. The intestacy rules are as follows. Number 1. Where the intestate is survived by the spouse, i.e. their spouse is still alive, the spouse receives the whole of the estate. Number 2. Where the intestate is survived by the spouse and also children, the spouse receives a base entitlement of $150,000 and the household chattels. After this amount has been assigned, then the spouse receives an additional equal share of the remainder of the residual estate, depending on the number of surviving children. However, where there is only one child of the intestate, the spouse and the child would each be allowed to 1/2 of the remainder of the estate. Where there is more than one child, the spouse receives 1/3 of the remainder of the estate, and the 2 children share the other 2/3. Number 3. Where the intestate is not survived by a spouse, but is survived by children only, the children are entitled to the whole of the estate in equal shares. Number 4. Where the intestate is not survived by a spouse nor children, the estate goes to the intestate's parents if they are alive, otherwise to the next of kin, and lastly to the government, where no beneficiaries can be found to benefit from the residuary estate.